Next on the calendar, number 33, People v. Nelson Miranda. Counsel?
I'd like 3 minutes rebuttal.
2?
3.
3. Very well.
May it please the Court, my name is Frances Gallagher, and I represent Mr. Nelson Miranda. The question presented here is, at what point do we evaluate the existence of exigent circumstances, police safety, and the preservation of evidence that justify a search incident to arrest of closed containers? Our contention is that if exigencies exist at the time of the arrest, the analysis does not stop there. The question then becomes whether the exigencies continue to exist at the time of the search of the object. And according to the Supreme Court in Gant.
Counsel, before you go on, are any of these arguments preserved?
Well, it is preserved here because in response to a protest by the party, the court below expressly decided the question that is raised here on appeal. In general, the court decided that this was a search incident to arrest.
This means that you didn't raise it, or your client didn't raise it. Relying on whether the court actually determined the issue.
Well, there was a motion to suppress the evidence, plus the court decided that this was a search incident to arrest, and then specifically decided that the exigent circumstances should be evaluated at the time of the stop. It evaluated the exigent circumstances at the time of the stop.
So are you suggesting once the defendant is handcuffed, it's over?
Once the defendant, I mean, that's the holding of Arizona v. Gant. And the Supreme Court said that if the defendant is secured or if the container is inaccessible to him, then the exigent circumstances can no longer exist and they cannot justify a search incident to arrest.
And where is it that the court decided there were exigent circumstances?
The court said that the reason that the search incident to arrest was justifiable was because of the dropping of the hacksaw at the time of the stop, and also because of the observations of the police, which was beforehand. And then the court also mentioned because of what they found in the satchel. So the court definitely was analyzing the exigencies at the time of the stop.
I guess on that point, it seemed like the court sui sponte decided itself that Miranda's search was incident to a lawful arrest, and that issue hadn't been brought up. The court did it itself.
Right, right.
I see.
Well, I mean, there was a suppression motion. I mean, no one had said search incident to arrest, if that's what you're asking me.
Going back to Chief Judge's question, so would there be a per se rule any time a defendant is handcuffed, there's no exigent circumstances that would justify opening any container or backpack or purse?
Well, I think the issue is whether the person is secured.
Right.
Not, I mean, and I don't know that that's always equated with handcuffing. It's whether the person is secured.
What if the person is secured, but they're secured in such a way that they could access some container that is on their person, for example? In other words, a person could be secured.
Then I would.
Could be handcuffed and could, reach in their bag and pull out a gun or a knife. Or
well, then I think the people, it's their burden to overcome the presumption of unreasonableness.
I'm talking about a presumption, but it's not a per se rule.
I guess if the person can do that, then he's not secured.
One of the things I struggle with this issue is the contemporaneous nature of the actions. An officer arrests and search, and usually that happens simultaneously. And this, I understand the bag, I'm not sure what kind of bag it was, but it was under his coat. So you would think that it seemed to me that the arrest and the search all happened simultaneously. Does that make a difference?
What the people what the people think is that if the arrest and the search are close in time, then you can presume that any exigent circumstance that existed at the time of the arrest continues to exist at the time of the search. But we know from Arizona v. Gantz that that kind of presumption leads to all kinds of unconstitutional searches. So we cannot make that presumption. We have to analyze the exigent circumstances at the time of the search. And so here,
Do the circumstances leading to the arrest and the search at all inform the analysis about the exigencies?
what this court has done is you examine the exigencies that exist at the time of the arrest, but the analysis doesn't stop there. If exigent circumstances exist at the time of the arrest, you go on to determine if they continue to exist at the time of the search.
See, I kind of view it as an officer's safety exception also.
Well, that's one of the exigent circumstances,
Right. There's
certainly.
an officer's safety exception. So if the arrest is they're not going to, and the searches are never going to happen exactly simultaneously, but if they happen, we're one right on top of the other, then it seems to me that there's a stronger argument, particularly in this situation where you have an object that could be conceivably construed as a weapon, then it seems it's much different from what you had in Arizona. I thought that was Arizona v. Gantz is what we're talking about, right?
Yes, yes.
Right, and that was a car case, as I remember it. And it was searching a grabbable area with an unsecured person. This is closer more to our Jimenez case and whether or not that applies, where I think you have a more difficult problem here, and because now we're right into the time between the arrest and the search and what's reasonable, what isn't.
Well, see, in Jimenez, I believe that you found there were no exigent circumstances at the time of the arrest. And so, but in other circumstances, if there are exigent circumstances at the time of the arrest, you continue and determine if there are exigent circumstances at the time of the search. And here, we have a police officer stopping appellant, pulling up his hands behind him. The weapon drops out. They place him on the hood of the car. They handcuff him. Another officer's present. Appellant's completely cooperative. And the officer testifies that he handcuffed him before they searched the bag. So, I mean, so it's a...
Well, in Jimenez, they removed the bag. Did he have the bag on him in this case? Or had the bag been removed before it was searched?
I think that's not entirely clear from the record. I mean, we think the best reading of the record is that it was removed before the search.
Is he handcuffed? Is he handcuffed hands in front or hands behind?
They pull his hands up behind him, they place him on the car, and then they handcuff him. That's the testimony that we have. But
Is this a mixed question?
Pardon me?
Is this a mixed question of law and fact?
No, this isn't a mixed question of law and fact at all, because the question is, what's the correct standard to be applied? And the question of what the correct standard should be is never a mixed question of law and fact. And the question here is...
What about the question of whether there were exigent circumstances?
But we're saying...
Determine the correct standard was applied. Then
Well, the question of exigency, if you apply the exigent circumstances in Gantt, then he's secured at the time of the search, and the search is therefore unjustified.
Counsel, could I just ask you to explain what you consider exigent circumstances? Because it sounds to me like any Terry stop where the police can frisk for weapons becomes an exigent circumstance in your view. Is that correct?
I guess I'm not following.
I just want you to define exigent circumstances.
Well, exigent circumstance is occurs when the police have a reasonable fear for their safety because they believe that, have a reasonable belief that he can reach for a weapon or that he can destroy evidence.
Right. So in this case, they stop him because they've seen him with something. They're not sure it's a weapon, I guess, but they stop him. Are you suggesting
I think they
that
didn't see anything. They saw him making motions.
They saw him making motions,
Near
right?
bicycles.
So they stop him, and then they frisk him. Is that are you saying that's an exigent circumstance?
I mean, the court below found the exigent circumstance.
No, I'm not asking you what the court below found. I'm trying to find out what you think is an exigent circumstance.
Well, I would say that at the time of the search there was no exigent circumstance because he was secured. Am I not answering your question?
No, I think you have.
Okay. And in light of Arizona v. Gant, we'd like this court to revisit language in Smith, because in Smith, there's language that I don't think was good law at the time, and that is certainly not good law at the time of after Arizona v. Gant, because it says that even if the person is secured, even if the bag is inaccessible to him, as long as the search and the arrest are close in time, the search is reasonable. And that's just it conflicted with Chadwick at the time, and it conflicts with Gant now. Thank you.
Thank you. Counsel?
May it please the Court, Andrew Seawald for the people. Good afternoon, Your Honors. Your Honors, the issues that the defendant raises in this case are unpreserved for this Court's review. The arguments that the defendant made at the suppression hearing were just about credibility, whether there was probable cause to arrest the defendant. The defendant
Counsel says that the court below preserved this issue for defendant by deciding there were exigent circumstances.
That's simply not the case. The Court never said anything about exigent circumstances. The Court did say that this was a search incident to a lawful arrest. The issue the Court was trying to decide was whether this was a lawful arrest. That was the issue that the defendant raised. The defendant challenged, and the protest of the party that the Court was responding to was the defendant's challenge to the officer's credibility.
And so in order to have this issue preserved, counsel has to argue, as she has, that the court found there were exigent circumstances.
That's right. And the Court, but also the Court, in order to have preserved this issue for defendant, with defendant not raising it at all, the Court would have had to specifically address the arguments that the defendant is raising now on appeal. And if this Court looks at its decision, People v. Pacino from 2009, I think that case, that decision is the most succinct decision on point for this case. And in that case, the defendant below didn't raise any Miranda claims, but the Court itself made a Miranda ruling, but this Court said that that Miranda ruling didn't preserve the defendant's appellate arguments because it didn't address any of the arguments that he was making on appeal. So just because the Court here said that this was a search incident to arrest doesn't mean that the Court addressed any of the arguments that the defendant made about exigent circumstances. And in particular, all these arguments about what the timing was between the application of the handcuffs and the time that the officer went into the satchel that was on the defendant's body, there were no arguments about that below, and there were no findings about that by the Court. The Court's decision didn't address any of those issues. And
isn't the logic, though, that the Court says, I'm making this decision on search incident to lawful arrest. There's only two bases for him to say that. It's either got to be officer safety or destroying evidence, right?
Right.
So you're saying that, so therefore it's not sufficient?
It's not sufficient for preservation purposes, because one of the main justifications, or one of the important reasons for the preservation rule is to give the other side a chance to address the basis for the ruling. And it's clear, I think, in the rationale for allowing a court to effectively preserve an issue for a party by expressly deciding it in response to a protest.
So the distinction between the time of arrest and the time of the search wasn't brought up at all?
To the extent it was brought up, it supported the decisions below that this was a contemporaneous search. The search was contemporaneous with the arrest. The record support, or the record supports the decisions, that this was a search incident to arrest that could have fallen within the exigent circumstances exceptions. There was no discussion below about whether the satchel was removed from the defendant. The defendant never made the argument that the satchel was removed somewhere. It was nothing like the situation in Gantt that the defendant is now relying on, where the defendant was locked in the back of a patrol car when the police went and searched searched a different car for evidence.
So are you saying that we don't need to decide the question of whether we have to view the circumstances at the time of the search or at the time of the arrest because they happened virtually at the same time?
I'm saying that the best way to decide this case would be on preservation grounds.
I understand,
because
but if we get beyond that, is that your position that we don't need to decide that issue because, for all practical purposes, they happen simultaneously?
Yes, but even further than that, counsel said in her argument that, in response to Judge Rivera's question about whether the bag was still on him, that she couldn't answer whether the bag even was still on him. And that illustrates the difficulty that this Court should have in even reaching the merits of the case. That illustrates perfectly that the preservation rule should control, and then beyond that, if the Court wants to get at the merits of the claim, this is a mixed question of law and fact. And whether exigency exists is a mixed question of law and fact. There's no this would not be the right case for the Court to revisit the standard on exigent circumstances, and certainly not an appropriate case for the Court to write a new rule that as soon as handcuffs have been applied to a suspect, that there can no longer ever be in any exigent circumstances. This would just not be the right case to do that. And it always comes back to preservation, because we don't know we don't know exactly where the bag was when it was searched. We don't know exactly how many officers were present when the bag was searched. Counsel suggested that the second officer was already on the scene. That's not clear from the record.
Was there any doubt he's handcuffed?
There's no doubt that he was handcuffed.
Okay, so how is he going to get to anything in that bag? Let's assume for a moment it's on him.
Well, people can do a lot of things even while they're still handcuffed. They're not straitjackets. And we don't know exactly how the bag was positioned in relation to where his hands were. We don't know how, whether there was some way for him to have gotten into that bag even while he was handcuffed. And that's why in all of these cases dealing with exigent circumstances, there are a host of factors that the Court can consider, including how many officers.
The bag closed?
The bag was closed.
Again, how's he going to get in that bag with his hands handcuffed? Let's assume the bag is next to his hands that are handcuffed.
Well, it's his bag. I'm sure he would know how to open it. And we don't know how difficult it would have been to open. And
How it's sealed?
I'm sorry?
Do we know how it's sealed? Is it a zipper? Is it a flap? Is it buttons? Do we know anything?
I'm
Anything
not
about the
sure.
bag?
I think we just know that it was closed, but we don't know we don't know exactly how. And
How exactly do we know it was closed? I'm looking at the testimony from the detective where he was asked, and the satchel bag was closed, correct? And the detective answers, as closed as a satchel can be. What does that mean?
I'm not sure. I'm not sure. I mean, we don't know whether it was zip closed. I mean, look, if the defendant wanted to make some argument that this bag was so well sealed that he never possibly could have gotten into it, and so let's go further than that, that the police officers, it would have been obvious to them that this bag was completely inaccessible from the moment they saw it. He should have at least made that argument. And without making that argument, it's really inappropriate for this Court in particular to now kind of comb through these facts and reach a conclusion contrary to the conclusion of the courts below. That we're able to examine this record and find support in the record for the facts that this search was roughly contemporaneous with the arrest, that it was only one officer on the scene, unlike this Court's recent decision in Jimenez, which I would just point out was after Gantt, and so could certainly have taken into account any change in thinking that might be suggested by Gantt. This Court in Jimenez took into account how many officers were on the scene, whether the bag had been removed from the defendant's person, and essentially took into account whether the police officers had complete control of the situation. And it's really and those are that's really kind of the controlling concept in these exigent circumstances cases, whether the police have complete control of the situation. Is there an overwhelming number of police officers? Have they removed the container from the defendant and brought it somewhere where it's locked inside a car, where it's around the corner, where it's in someone else's hands? And once all of those things have happened, then the exigency would not apply anymore. But here, where the events happened simultaneously, where the satchel may have still been on his body, where he had just thrown down a hacksaw, it was nighttime, this police officer had watched him go after one bicycle after another with some kind of tools. He doesn't know exactly what kind of threat he's facing. He testified to his fear for his own safety and that of his partner, and I would point out that was something else that was missing in Jimenez. There, the officer said they never testified to having any fear. So under all of these circumstances here —
Well, that's why they've handcuffed him, no? Isn't that why they handcuffed him?
Absolutely.
To secure him so they would not have to worry about their safety?
Absolutely. But it's never been the case that handcuffs alone end the inquiry. Certainly handcuffs are an important factor that the court should take into account, any court should take into account in deciding whether there really is a threat still and any possibility that someone could get at that container. And so I'm not asking that that be disregarded, but it also needs to be considered under all the circumstances, and there shouldn't be some new rule that would restrict police officers from being able to preserve their own safety, preserve evidence when acting in the context of a street encounter where they don't know exactly what circumstances they're up against at the moment that they're developing. And so for all of those reasons, but again, primarily for just the simple preservation reason, I ask this Court to affirm the decisions below.
Thank you, sir.
Thank you.
Whether or not the bag is on him at the time of the search is totally irrelevant under Gantt because the defendant is secured. And so, and also, if the people think these facts were so important, it was their responsibility. It's they have the burden of overcoming the presumption of unreasonableness at the hearing and demonstrating that a search incident arrest to the exception to the warrant requirement applies.
Do you get the point that he's making, that you didn't argue the cases that you're now arguing in front of the trial court or the suppression court?
But that's always true in a 470-052, in a 470-052 type of preservation, that the defense counsel didn't make the arguments that are being made on appeal, but that the court's decision preserves the issue. I mean, look at Prado, for example, decided by this court. All the defense counsel did was move to dismiss for lack of sufficiency, and the court below makes a decision based on confession corroboration, and confession corroboration is the issue on appeal. I mean, you know, no arguments were made by counsel below, and that's just universally true with this type of preservation. And as far as Jimenez, you didn't have to consider Gantt because this court found that there were no exigencies at the time of the arrest, so you didn't have to proceed. You do have to proceed, though, if there are exigencies at the time of the stop. Then you have to continue to proceed and determine whether there are exigencies.
Mr. Sewell's other argument is, you know, the first part of the appellate term said that the defendant concedes it was a lawful arrest. The arrest and search were contemporaneous. The backpack was large enough to contain a weapon and was within the defendant's grabbable area at the time of his arrest. Soon after police saw him discarding a hacksaw, and surrounding circumstances supported the reasonableness of the officer's stated fear for his safety. How do we challenge that?
Because they're looking at the time of the arrest, and they should have proceeded to also examine the time of the search, when the person was secured, and when.
Do we know what the difference in time was between when he was arrested and when he was searched?
I don't know that we know the.
So how do we know that there is any meaningful
Yes, we
difference?
know. We know that they pull his hands up behind him, say, "Stop, police," place him down on the hood of a car. Another officer comes from across the street. They handcuff him. They then search the bag. It's not, you know, all at one time. And Gantt tells us you cannot presume that exigent circumstances that exist at the time of the stop continued at the time of the search. Thank you.